let me show you what I'll be filing today. Here in the court office of Hamilton County Chancery Court, I'll be filing a defense court and its plenary authority. Now, it's not just inherent authority. Right here, we have 4 pages, limited in length by Judge Bennett, 4 pages describing the inherent and plenary authority of Chancery to mete out justice in our case. Now, our case is one intending to overthrow universal mandatory auto insurance in Tennessee. And the judge asked the Commissioner of Revenue, and he asked me to define his authority in a review of a contested case in agency. In other words, when you have a contested case in agency and it's appealed, it goes to Chancery Court in Tennessee. And the statute allows me to appeal a negative ruling from the Commissioner of Revenue in my home county. So the Attorney General's office has to come here for hearings. And so that's where the court case is right now. It's a separate lawsuit appealing a negative ruling about my tag. In other words, I'm suing to have my tag on my famous Honda Odyssey minivan restored. It was illegally revoked under a program which we call the Eye of Sauron. The Eye of Sauron program is an illegal, arbitrary, and capricious, unconstitutional, ultra vires program to compel 100% of registrants to have insurance. Well, the statute doesn't require 100% of registrants of motor vehicles to have insurance. It requires only one group of people, and that would be people under suspension. If you're suspended in Tennessee and you have and you want to maintain your tag, you can keep the tag, you can keep the privilege. You can keep the privilege only if you have insurance. But it's not just any insurance, it is insurance that is called a motor vehicle liability policy. It's a special policy that the insurance companies have to sell. They don't have the option of not selling. They have to sell it. And that is because it is high risk. By that, the statute indicates that the insurance company, if there's a $5 million car accident that you cause and you have a motor vehicle liability policy, the insurance company has to pay the entirety of the amount, the whole amount it has to pay. And that's because the state has an interest in everybody in a case to be made whole. There's a public policy purpose, a public interest purpose in having that special policy. So if you're a high-risk person on the road and you have a suspended license, you get to keep the privilege on condition of a motor vehicle liability policy. Those are the only people who have to have insurance in Tennessee because we have a financial responsibility statute. Okay, it's not mandatory insurance. It's called financial responsibility law of 1977. And that's what I'm defending. I'm in court defending that statute. And this case, let me show you. This case has this defense of the authority of the court to give justice and not to be constrained merely by the final ruling out of Department of Revenue. And the arguments are very important because equity promises one case, all the issues are brought into the case, and all remedies that I'm demanding, remedies are afforded to me. I have a right to the remedies, including a special master, including reformation of the Department of Revenue, and requirement for cooperation between the 2 departments involved in this scam, and changes and redactions in notices that go out to the public. And I'm demanding also a mass restitution program where tens of thousands of people illegally convicted under TFRL, the Tennessee Financial Responsibility Law, get restitution, a one-time payment for a false conviction. Think about roll-on convictions of people who are convicted of driving on revoked. Why are they revoked? Well, because it didn't have insurance. So those convictions also can be thrown into doubt in a mass program that I'm proposing.